Assalamu alaikum and welcome to our obligations class. As you probably guessed, I'm not here at the moment, though I'm here because I'll be traveling in Hajj, inshallah, during the time in which this lecture is being presented. But that said, I didn't want this to be an occasion at all for you to miss out on any class time because I know a lot of you are, you're probably in a existential dilemma. Oh no, no classes. What do I do? I need more classes. But don't worry. I tried my best to make sure that you get as much class time as possible. In fact, we can always go over 5-10 minutes. It's no problem by me. So what we're going to do this class is just a review of last class as well as touch upon the readings that start getting us into really the core material of the law of obligations, contracts. And we're going to talk about will theory. So we're going to finish off the different sources of obligations today, and we're going to do a little bit about will theory, just so you can get on your way. And let's jump right in. And again, any questions going into the class? If you do have questions, sorry I can't take them right now, but most certainly I'll try to keep up with email. And of course, when I get back, we'll continue with this at a proper pace. We might have a couple of makeup sessions, but don't worry, by no means will you be in any position that would put you worse off than your colleagues. You're probably better off in the sense that the class is very small and it's much more engaging than other semesters, which is very good. I like that very much. Well, you all remember this slide. Legal events are situations where an event occurred in society and legal consequences flow from it, such as a person being hit by a car mistakenly or a child being born. And a legal act is where the party commissions or has an intention that ends up creating the legal relation, like a contract. And that's what we went into last class, and how there are contracts and quasi-contracts, which are legal acts, and then there are harmful acts and useful acts, which are legal events. And these trace back all the way to Roman time, these categories, which is very interesting. I mean, Hayran Shuda. It's very interesting to see how Roman law has an impact even in the operation of our law today here in Afghanistan. And we started to go, I won't go into detail about nominate versus innominate. We did that in class last time. We started to talk about quasi-contract, and another word for quasi-contract is unilateral will. Because it has everything that a contract has, a quasi-contract, like a quasi-intelligent person. Everything that an intelligent person has, a quasi-contract has everything that a unilateral will is a quasi-contract because it has everything that a contract has, except that it only has one party involved. And that is, for example, with divorce. It's just a unilateral pronouncement by the male of the talaq that creates the legal effect. In inheritance, it's just the person who writes his will or that produces the legal effect. It's not an issue of whether there's an acceptance or not. And there is acceptance or not later on, but we won't get into that in detail. The importance is whether just one person's actions is enough to create a legal consequence. And again, what I mean by that is that there are certain results that flow from the pronouncement just by one party. And we went into the case of a prize last time. I already let you read Article 756, so we're not going to go through it again, but with a prize, it's considered a unilateral will, that is a quasi-contract, because if a company like Roshan announces that if anyone bikes from Kabul to Pagman in an hour, they get 10,000 Fs, right away, that's considered enforceable. People don't need to call in and say, I accept and I'm about to start biking. So just hold on. A person, let's just say Ahmad, might have been bike already, about to start going there and not even aware of this prize. And when he starts going towards Pagman and completes that trip in 1 hour, then he's eligible for the prize, whether he was aware of it or not. So it's just that one party saying that it's going to provide a prize that ends up being enough for the party to have, for there to be a legal consequence. Uh-oh. My computer seems to have fallen asleep. Just hold on one second. Good. And so, no more sleep time. That's enough sleeping for one class. That's why we have a unilateral will. And the main reason it's important is it's just an issue of fairness in society overall. I mean, one, it is a type of legal relation that exists. So with divorce with inheritance, you do have unilateral will, just a one-sided pronouncement by a party that creates a legal consequence. And two, for the case of like the prize, it's seen as fair in society that if a party makes a legal pronouncement that another party then fulfills, then it would just be fair that they be held to that legal pronouncement, even if it's just one-sided. And so we don't go into unilateral will in any more detail than what I just said, just because it's not something that you have a huge amount of, that has a huge amount of importance in society. I mean, if it comes up, you can deal with it as it comes along, but as long as you know that category, that's more than enough, and a little bit about it. Just a little bit about the differences is that, I'll just go through the differences, Colin. One, volitions means intention, and so it only requires one intention. The intention of the party creating the unilateral will, so the party that's creating the obligation. Next, it doesn't require consent, and the goals are generally different. Like you have economic goals with contracts, and with unilateral will, it's not the same. And there are different formalities, and we won't get into that in detail, but there's certain formalities are considered like requirements that have to be fulfilled for the contract to take place. So don't worry about that in detail. And so, we'll now go on to legal events. And with legal events, I mentioned two categories, useful act and harmful act. And so, with harmful act, we are talking about the case where, I mean, we went over these, we already went over Article 496, we're not going to go over it again. But we talk about instances where something has happened, and because of that, there are legal consequences. So, for example, someone might have died, and legal consequences flow from it. There might be a passage of time, and because so much time has passed, you can't bring an issue to court anymore, and so an event has occurred. You reach a particular age, and certain consequences flow from it. But all of these are considered legal events, and the two main ones, the two categories within legal events are harmful act and useful act. Harmful act, it ends up being the case of the person being run over in the street by mistakenly, and that's the whole entire course 312 Obligations 2, which hopefully we'll all be doing together next semester, or a lot of us. That's a harmful act. So we won't spend much time on harmful act, just to give you an idea of useful act, because again, there's no course about this because it's such a small area of the law. Useful act it's sometimes considered unjust enrichment. Unjust enrichment, because it's this idea that a party has received a certain benefit and they shouldn't have received that benefit. Like they've received money when they shouldn't have, or they've received a payment when they shouldn't have. And so, here's Article 800, and I'll read it for you, just for the sake of simplicity. If a person pays or delivers something to another person, thinking that he was obliged to do so, and it is proved afterwards that he was not obliged to do so, he can demand its return. And so, what it's saying is very simply that a person got something, but they didn't deserve it, because I had a contract with, let's just say I had a contract with Kalimullah, but I ended up giving all the money to Ghazia instead. And then I realized, oh shoot, I mixed the two up. I can ask Ghazia for the money back so that I can then give it to Kalimullah. And that just seems fair. There's no actual, I mean, it's not clear that I would have a right to take it back unless it was provided by law. This is what this law does. It provides total clarity to this matter. So Ghazia can't run off and say that, oh my God, I had so many things I wanted to spend it on, etc., etc. That's not enough. I end up having the right to get the money back because it's now mentioned in the law of unjust enrichment or useful act. Not just that, but let's just say the person who takes the money, who receives the money that isn't theirs, says that, oh, this person mistakenly gave it to me. I'm going to quickly use this money to give it to someone else. well, in that, or you use this money so that this person doesn't ask it back from me. If this person is kind of in, we call this bad faith. That person, they could have just told you, but instead they purposely tried to use the money for their own benefit. In that case, you can even, the party who paid mistakenly can even ask for compensation. That is, if I give the money again to Ghazia, and I ended up losing that money, and the money wasn't returned to me because of bad faith, meaning the person who had taken it had understood that it was mine, but they didn't tell me, but rather they tried to mislead me and tried for me not to take back the money, then I can ask for the money back and even get compensation for any losses that I incurred. So for example, if there was a late penalty, or if I had if I suffered like a delay in the delivery of goods, which delayed the construction of a building, all those I can ask for as compensation. Here, another example is right here. Let's just say I ended up having in a contract a statement that says the payment is due February 3rd, 2018. But it has some script in the contract. Photocopy that I have, it had a bit of a scribble, and I wasn't sure what it said, so I thought it said, I thought it said 2016. And so I paid it in 2016, then I got a copy of the original contract and said, oh wait, it was due 2 years later, it's not due right now, it's due in 2018, not 2016. If a mistake has been made, and the payment has been made too early, the party can ask for that money back, because there was a mistake on their part, and the reason the law permits this is that it's just seen as fair for doing so. And the emphasis here is without knowing it. So without knowing it means that it wasn't their intention to pay ahead of time. They just weren't aware that they were paying ahead of time. So this is what we mean by useful act or unjust enrichment. I had one student ask me, like, why is this called useful act, actually, at the end of the day? What's useful about it? I mean, I can't really give you a great answer because that's the title in the Civil Code of Afghanistan. I mean, I could postulate that it's not harmful in the way that harmful acts are harmful, like running over someone, but it's useful in the sense that, you're providing the person who gets the money early or gets the money when they don't deserve it with a particular benefit. So in that sense of providing someone a particular benefit, yes, it's useful for them, even though it's not like useful in a good sense. They've gotten a benefit which they don't deserve. So that's, probably a reason why it's called useful act, but I can't give you a lot more details as to why. It's just, that's the title. We just have to live with it and go with it. Harmful act, I think, again, I mentioned to you, but we're not going to go into any detail at all, specifically because it's a class. As long as you understand that it has to do with the area of law where you mistakenly cause an injury or a problem on someone else, mistakenly, and so you just have to correct that. And there's no contract involved. And so let's just quickly go over some examples. And you have this in the slides, which I told you should review, but we'll go through them together. This picture says, oh my God, I didn't have to pay that guy a penny. Why did I pay him? This is clearly an example of what we just talked about, useful act. This person paid someone and the money wasn't owed, so, they're allowed to ask for that money back. Useful act. Next, public library, donated by XYZ. We don't know the person, but it's a public library that's donated by a particular party. This is actually, we're going to see later on, a contract. Like, it's a one-way contract, but if you donate something, the party that's accepting still has to accept that donation. And so it's considered a one-way contract. And so just wanted to bring up that example here. Next, collect 1,000 caps and get $100. What does this sound like? Sounds a lot like our Pahman to Kabul Viking example. It's a prize. So if a person ends up collecting 1,000 caps, then they'll end up being eligible for that award. That was my book, now it's mine. It depends what the consequence is. One, if they end up getting into a fight, there might be a criminal issue here. But if a person mistakenly gave someone else their book, it could be an issue of useful act. The person is allowed to ask for that matter back. And it could be even both, criminal and a useful act. There's no reason it couldn't be both areas of law. What about these two, Bill and Ben? For one, it's son Ahmad Maryam. I want to buy these sweets for 20 pence. Yes, please. Can I buy your sweets for 20 pence? Yes. This is actually a simple contract. Offer and acceptance. An agreement between two parties. So that was pretty straightforward. This here, a person, is working on the job site. Maybe this piece of wood was a bit weak and it broke, and because of it he fell and hurt his knee. Doesn't seem like it's going to be a contract because there's no clear contractual issue here. Like there's no party that's providing another party something else. It seems that it would be an issue of civil responsibility or tort, a harmful act. And it seems like there is a harm that's done here. This is what we'll talk about in 312 next semester. What about here? This accident. Car crashing into another car. I mean, we don't know if it was negligence, meaning the car was going too fast, in which case it might be a criminal issue. Here, it definitely would seem to be a harmful act issue, because cars hit into another car, probably some harm has occurred because of it. Next, trespass. Private property, what's it called? It's implying don't go past here. Sometimes, in harmful acts, there is this area, there is exceptions as to when a party will be held responsible, and that's if they take certain precautions. So if there's a fence that you're not supposed to climb over, but you climb over it and get injured, that's kind of your fault. I mean, you did climb over a fence that you weren't supposed to. So that was a precautionary measure made by the person who knew that I have something dangerous on my property, so I'm putting a fence up so that you don't get hurt. Similarly here, they're putting up a sign saying, don't come to this area, it's dangerous. So if you do end up going to that area, it is somewhat, your fault. So it could be an issue of harmful act, but it could be a defense to harmful act as well. That's more than we need to cover in this course, but I just end up having this slide just to give you just to widen your mind in terms of the applicability of this law of obligations. That's the last slide. Let's skip that one because I think you get the point by now. We'll go on to the most exciting thing in the world, and that is contract law. I kid you not. This is exciting. So I'll read the article with you. As you probably guessed, I don't read from the slides. It's just in the way I've heard some professors might do so at the university. It's absolutely not my style. I'm just doing it here so we can go along at the same pace. But don't worry, it's not going to become a norm. Neither are these videos. So a contract constitutes the agreement, important word, of two wills for the creation, modification, transfer of a right. So the agreement of two wills. That's the first point that's important. And second, as a result of the contract, obligations are created, we'll just say. So it's an agreement of two wills. As a result, obligations are created. That's really what 497 is getting at. It's really that core article that talks about contracts exist when there is an agreement between two parties, and then from that flows certain legal consequences. I just want to make an important point. Where are my markers? Leave them in the room. I guess I left them in my office. So we won't be doing any markers today on the board. But I want to make this separation between the civil code of Afghanistan and the commercial code, because this is very important. And if you remember way back when we started to talk about the different divisions in the legal system, we separated obligations and commercial law. And there are reasons in history as to why that happened. But in Afghanistan, we have a simple civil code and commercial code. Now, the civil code governs contracts generally. So the rules that we learn apply to all contracts. So that's why it's the innominate section of the code. Certain contracts will also be governed by the commercial code. And what that means is there are special rules that govern certain types of contracts by their nature. For example, Articles 18 and 19 of the Commercial Code, they identify what types of issues are governed by the commercial code. And examples are, these are bigger commercial type properties. So, for example, like the establishment of a power plant, or photography or printing, establishment of these types of businesses. Another example would be like theaters, if you're making a theater or like a movie building. If you're engaged in the transportation business, so whether it's trains, planes, other types of businesses, or you're a public utility, meaning you provide water to the country, or your company that does so. All of these are considered to be commercial transactions. Oops. Article 19 provides other areas in which the transaction is considered a commercial transaction, such as like if you work for commission, if that's the type of contract that you have, or it's a contract of insurance. I'm not going to go through them in detail. I just want to make sure that you're aware that all contracts are governed by the civil code. Other contracts also have the commercial code that governs them as well. And we already went to a similar point when we talked about innominate and nominate. All contracts are governed by innominate rules, but they're also governed by further rules, such as rules on nominate contracts of sale, hire, employment, etc. So let's just see which law applies. We talked about various forms of law: commercial versus civil, or in terms of the civil code, public versus private. So, government of Afghanistan prosecutes a criminal. It seems to be criminal law in the public law sphere. Government of Afghanistan hires a company to do renovations, and then they're going to court because that company wasn't paid. Well, if it has to do with renovations, the government is acting as a private party that contracted with this renovating construction company. So this is private law. This is it seems to be a general contract. It might be the CCA, depending on the nature of the contract. It might be a commercial issue as well. Khadija buys an airplane ticket and wants to know the laws. Airplane, we just mentioned, is definitely an issue of commercial law, and the CCA also applies. Asma stepped on an electricity line, was injured. Seriously. So Asma stepped on the line, got shocked. This seems to be an issue of harmful act, because it's about injury and this exposed wire. Then Mike scored 100% on his obligations exam, and after a week he realized the professor had offered a ticket to a concert. Put Madonna. She's kind of old school. She said Justin Bieber, someone else everyone knows now. A concert for any student scoring 100%. This seems to be useful act. Not useful act. Quasi-contract, so unilateral will. This seems to be unilateral will, like that prize example that I brought up. And so it fell under unilateral will. Today we start contracts, and we're going to figure out, base question that I tried to get at when you did the readings, those two articles, is why should we even have contracts in society? And I guess the main reason we want contracts in society is that parties have willed these contracts. You're going to come across certain words that mean the same thing. They've willed, or they have the intention, or volition. Volition, V-O-L-I-T-I-O-N. Volition, intention, will, they all mean the same thing. They have this meaning of they intend. So, at a conceptual base level, the reason we hold contracts to be an important institution in society, to play an important role, is that parties are writing down formally that they want to be held to a particular obligation, and they're going to provide that. So the moral, or I guess I'm going to say the very base understanding as to why we justify contract law as a discipline is that the parties themselves have said we are going to fulfill this obligation. And so we want to hold people responsible for the commitments they make. And we're going to hold them responsible in a legal sense, in that they have to provide that commitment. And the only way an economy can operate is if we hold people accountable in that sense. And that's, I guess, the conceptual justification. And we just went over Article 497, how the contract is an agreement of two wills. And the Majallat al-Ahkam, which we mentioned last class, says the same point. Contract is something where the parties bind themselves. They agree amongst themselves that they want to be bound by the particular agreement that's being made. And so, as we slowly go on, we see that one of the criteria that a party has to have is capacity, meaning they have to have the proper state of mind. So I'll let you read Article 512, either from here or your booklet. Quickly, what it's saying is that expression of will is void if there's a state of unconsciousness or mental disorder, just being out of an individual's right state of mind. And so let me read this example with you. Qais has a medical condition which makes him occasionally lose full awareness of what's occurring around him, though he's still awake. One day, Qais was in the market and went into a state where he lost his awareness. He then picked up some fruits and was about to pay for it. A few seconds before paying, he's fully aware, his full awareness comes back, but he still decides to buy the fruit. So he picks up the fruit, not aware of what he's doing. 2 seconds before buying it, comes back to his regular state of mind and continues to buy it. Would that be a valid expression of his will to buy it? Yes. Article 512 doesn't apply here because his being in a state of out of consciousness or not in a fully present state of mind doesn't coincide with the transaction. At the time of the transaction, he was in a proper state of mind. 512 doesn't apply. Excellent if you could see that coming, and I probably would guess most of you would have. And the next question is, how do we actually go about assessing someone's state of mind like Qais? It's very hard to figure out whether their states of mind are different. And so what legal scholars have come up with are these two notions of subjective intention and objective intention. And with subjective intention, it really has to do with what in your mind are you actually trying to do. So what is the real essence of what you're trying to get at? Objective intention is, what does a person see in your transaction? So most of the time they're going to coincide. If subjectively in your mind you want to buy this bottle of water, then you want the water and you want to provide $50 to 50 apps to get this water bottle. Then objective intention would be, if a person was looking at the situation, what would they see your intention to be? They see you giving out $50 and they see that you want to take the water bottle for that. So there's a coinciding of subjective and objective intention. Sometimes it's not the case, and that's where problems arise. But the thing is, it's very hard to know exactly what a party really intends. And so the best we can do is try to figure out what do they intend based on what objectively they're showing. So me paying the $50 and grabbing the water, it shows that I probably want this bottle of water for 50 apps. But and we can probably guess that's what my subjective intention is based on the objective assessment of my actions and the intention that I'm showing. So this is this distinction between subjective and objective intention. I'll give you a few seconds to read these 3 slides. A little bit cut off at the bottom here. And it says, the first one says, expression of will can be done orally, or it can be done in any other way that conveys will. So, for example, a party says that instead of me saying, I agree to take this water bottle for 50 apps, I could say it orally, or I could just do, which happens all the time in the cafeteria, It's not even like that. Often you're in the cafeteria, you're like, so here's a water bottle, but your friend, you need the latest Facebook updates, so you don't even have time to look at the person who's providing you. And then you go scrolling and then take out the money. And keep scrolling down. Anyways, this is how transactions happen. But no one's going to say it's not an actual real transaction. It absolutely is. Next, expression may be taken implicitly. Will may be understood implicitly. And so, it's actually, in my opinion, they're virtually the same. We could consider explicit versus implicit it's very much the same as buy an action. So, for example, if a person says that they're willing to buy something for you to you for $50, and you're thinking about it, and you just give out the $50 and walk away, it seems that you've implicitly said yes. And that's very similar to transactions. So there's really, I'd say, no difference. Put one or the other, you're correct. The last point is quite important, and that is, if your will is contrary to your conscience, not conscious. Consciousness is like you're aware, like awake and not. When your conscience means like what you're thinking in your mind, or like you could say, yeah, what's you're thinking. So if your will is contrary to your conscience, that's not considered void, except if the party that was contracting with you is aware that there's something wrong between what this person is thinking and the way it seems they're thinking and the way they're acting. What this is taking into account is that subjective and objective intent might not be aligned. And so when the two are not aligned, we'll generally prefer objective intent. What is the party doing? Except when the other party is aware that I can see that the objective and subjective intent aren't coinciding. What it means is probably we'll go with that means what I'll gonna base my decision on the subjective intent. So it actually puts a lot of onus on the person who is on the other side of the transaction to be aware of what's going on. So here's a very simple example. Ruhula owns a company, sells firewood. Bukhari, and he takes he provides wood every Monday. Bukhari wood for 1,000 kgs for 5,000 AFs. 100 kgs, sorry, for 5,000 AFs. Then in a particular week, in a particular pickup, he picks up 100. Someone picks up 100 kgs for 5,000 AFs. Then in the following week, he is informed that the price has gone up from 5,000 to 8,000. And so the buyer is thinking about it, and without even providing, a response, he still comes to the store, takes his 100 kg of wood, and pays the 8,000 AFs. That seems very clear from the articles that we were just going through, articles 509, 510, that it's a valid transaction. He didn't have to say anything. His action just provided evidence of there being a valid transaction. So we want to talk about, we just talked about will theory. That is, if a person wants to be held to a contract, they should be held to it because that's what they're agreeing to. They're agreeing to provide a particular obligation. We sometimes call that the meeting of the minds. It's called will theory or a meeting of the minds because two minds are agreeing that they're going to be held to a particular standard. So how is will theory how does it have certain deficiencies? One deficiency is that we give deference to objective intent, but if we're talking about our real will, what we're thinking about is what is the actual intention that the party have. That if we want to be true to will theory is really based on the actual will, meaning the subjective intent of the party. We can't just say objective intent is easier to assess, and so we assume that's the same as subjective intent. There is a difference there. Will theory really is about subjective intent, but the way we operationalize will theory is by objective intent. And so there seems to be a disconnect there. And the second point is that, will theory might mean the parties agree on some matters, but it doesn't absolutely mean that they've agreed on all matters. And a lot of these contracts have gaps in them. You can't have every single possibility mentioned within a contract. It's just not possible. And so, the way that these criticisms are sometimes dealt with is that, one, it's really up to the court to decide what the parties were thinking about, and two, in terms of, not knowing every aspect of the contract, sometimes what will happen is that we will just base the contract's understanding on the general norms of society. So custom comes into play here. But it certainly doesn't do a great rule because to what extent, can we take the knife, cut someone in half, go into their head and look around and say, oh, that's exactly what their intent is. It just doesn't happen in society. We can't really operate in that way. And so this dilemma between objective and subjective intent is going to persist. But at the end of the day, it's probably the most preponderant or most convincing theory as to why we have contracts in society. It's because two parties have agreed that they want to be held to a particular obligation and particular responsibilities, and so we're going to hold them to those so that we can build economies. The last point I want to actually introduce you to is this concept of adhesion contracts. And that is, an adhesion contract is in Article 592, and it says that it's really that it's simply one party provides an offer to another, and the conditions are not negotiable. So it's just you take it. Here's what you can have. Either take it or leave it. 50 Fs. That's it. I mean, in the market, it actually often says this is a 50 Fs final sale, and then you say 45, and you say, okay, actually 47 final sale. That's not what we mean by adhesion contracts. It's like Roshan. Roshan, you can't really negotiate with them, and if you are, that means you're so rich. That means you're like super important and rich in society, and we need to become better friends. But otherwise, I mean, generally, most of us, are not powerful enough as individuals to be able to negotiate against big companies. And these big companies, they just don't have time. It's inefficient. And so they provide contracts which you just agree to or you leave. So with Roshan or AWCC, you accept it or you leave it. You don't say that, no, it's 500, but I want 575 megabytes. It's like, okay, just be on your way. We're not going to deal with that. Those are called adhesion contracts. Even in the cafeteria, I mean, you can't really negotiate lunch being 75 Fs instead of 80 Fs. It doesn't work that way. Just take it or leave it. And Article 529 is very important because it establishes the existence of adhesion contracts. The majority of contracts that we have in society are actually adhesion contracts. So it's something important to note. This is the last slide that I have for this class, and we'll just quickly go through it so we can figure out what the answer is. Bill wants to sell his car for to Todd for $1,000. Todd says nothing, but immediately pulls out the money and gives it to Bob. Is it a valid meeting of the minds? Yes, because will can be expressed not just orally, but through a transaction. Not just written or oral, but through a transaction. So 509, 510, I think it was. Before accepting an offer, Ahmed says, I really don't want to, but here you go. It seems here there's a difference between the subjective and objective intention. I mean, it might not be true. It depends. So we really would have to figure out what's going on in this transaction. Like one, if the person is being forced, like they don't want to but they have to, it seems there that subjective and objective are misaligned. So Article 2 or 3? Yeah, 513 ends up being implemented here. But it might be the case, many people, they get into a heated argument in the market. It's like, they say like, ibis yakimatas, but they give the money. They still actually want the item. They're just kind of making a scene. And so we have to figure out, is it an issue of a person making a scene, or are the subjective and objective intentions misaligned? So then we'll have but assuming they're misaligned, it wouldn't be a valid contract. So 513. I wouldn't make any question this obscure at an exam or anything. It's just us to exercise here. Bilal and Asma made a contract. However, Bilal was just in a car accident and doesn't seem to be aware of what's going on. It seems that this wouldn't, because this is an issue of capacity. Capacity, meaning Bilal isn't in his right state of mind. And so Article 512 would apply here. That he doesn't have capacity, so it's not a valid contract. The last one, John and Sue made a contract. John comes back the next week to cancel the contract, saying that she felt she was compelled by her sister. So John and Sue make a contract, and then the following week, Sue comes back and says, I didn't actually want to make that contract last week. In this case, you can't really argue, unless John had known that at the time of contracting, because we have to assume that the objective intention is the same as the subjective intention. Otherwise, we'd be asking too much of the person who is on the other side of the contract. So in this case, no. You can't just say that you were forced. I mean, John, in good faith, went to the contract. He's basing it on the intention that he's seeing this objective intention, and he assumes the objective and subjective are coinciding. And so here Article 513 applies, but the first part saying that we first will decide the contract based on the objective intention, despite the subjective not being the same. And so that's the article that applies again, 513. Great. And so, as a summary, will theory still is probably the most preponderant, dominant theory of why we have contracts in society. That said, there are still shortcomings to it. It doesn't address the realities of how we go about contracting. I mean, we don't, at the end of the day, know the total exact will of the parties. I mean, we just pragmatically go on with subjective, objective intention, and also providing certain norms by which we'll hold the contract enforceable. So that's it for today's class. Thank you very much. That's probably it before I come back from Hajj in terms of classes, but I do recommend you go over this class as well as offer and acceptance, which will be the class that we have right after the break. And luckily the the makeup this semester there is a makeup period in the schedule, which ends up being immediately after our obligations class. So a couple of times we'll do that just to make sure that we're up to speed. And otherwise, we'll just charge on with the semester, and hopefully, hopefully today's lecture was clear. And if you have any questions, you're welcome to email them to me. Otherwise, we'll just continue with discussions after the break. All right, Assalamu alaikum.